Na tusonge mbele mtazamaji. Chama cha wanasheria nchini LSK kinatarajiwa kuanzisha mgomo wa kitaifa na kususia shughuli za mahakama, ikidai kwamba idara ya mahakama imeshindwa kushughulikia ipasavyo malalamiko kuhusu ufisadi, ucheleweshaji wa utoaji wa haki na pia ukosefu wa uwajibikaji katika mfumo wa mahakama. Mgomo huu unatarajiwa pia kushuhudia mawakili kote nchini wakisusia kuhudhuria kesi mahakamani, hatua ambayo LSK imesema ni maandamano ya kisheria na yenye uwiano yanayolenga kushinikiza mageuzi katika mfumo wa utoaji wa haki nchini. Chama cha mawakili nchini pia kimeorodhesha majaji 12 na mahakimu wakuu mmoja anayedai wanahusishwa na ukiukaji wa huduma za mahakama.
In the cold, and it is yet another sign or signal that Kenyans have been left in the cold and the judiciary is not welcoming them. But we will continue fighting until we accomplish our goal, whether we are in the cold, whether it is raining, sunshine, or whatever weather. Continue.
Thank you so much, President. Our first question is, would you mention at least just two of some of the most outstanding cases against either a judicial officer or any member of the judiciary that you think that is in question in regards to integrity or even corruption itself? The second question, how do you differentiate yourself that you are not a state agent in that these are interesting times? We've seen in the past LSK supporting the judiciary when there was some sort of interference by the executive. This time you're on the other side. How do you defend yourself that, we are not being agents of the state or executive?
First, let me say Chapter 10 of the Constitution, which establishes the judiciary, identifies two key pillars for a strong judiciary in Kenya. One is independence and one is accountability. As the Law Society of Kenya, we remain very committed to pursuing the full realization of both pillars. And anytime we find threats against independence of the judiciary from anyone, the executive, legislature, county governments, any individual or anyone in particular, will always stand very firmly in support of the judiciary. The judicial oath asks every judge to administer justice without fear, favor, prejudice, influence, ill will, or even a benefit to one person that is contrary to the law. But the second pillar is accountability. And independence should never be used as a shield against accountability. The Constitution of Kenya creates several accountability mechanisms. So what we've noticed in the past is that as we have kept pushing for independence, some members, not by far the majority, but some members of the judiciary have used that push for independence as a shield against accountability. So we are now rebalancing the scales. So we are not people who are acting as agents of any person apart from the public, who have the sovereign will and who give delegated responsibility to the judiciary, delegated authority for them to act for the best interests of Kenyans. In regard to some cases that stand out regarding the judiciary, let me say this. Not so long ago, there was an investigation being undertaken by the Ethics Anti-Corruption Commission, where there was signals of clear cash being transferred and discussions about bribery. And a particular judge was named. And that judge was actually part of the people being investigated. She went to court and got court orders to stop the Ethics Anti-Corruption Commission from going further with those investigations. There have been cases where judges have had complaints against them at the Judicial Service Commission. Those complaints have been filed by Kenyans and in some cases by lawyers acting on behalf of Kenyans. They have been requested by JSC after they have noticed that there is an issue to be responded to. They have been requested to file a response. Instead of filing a response, they have gone to court so that the court can stop JSC from even daring to ask them to file a response to those allegations. So those are some of the reasons why the targeted court boycott is going to continue. But for the general court boycott of today, there are several issues that we discussed in our statement that we issued on Friday regarding accountability, regarding performance, issues of delays, backlog, issues of inefficiency in the registry, poor performance, misconduct by some judicial officers, and of course the monster of corruption that has been running rampant in certain sectors within the judiciary. Our second question. The targeted boycott will continue as long as it is necessary to get accountability. And in the statement we issued, we said, once those court orders that are stopping accountability are lifted, in the case-to-case basis, the boycott will stop against that particular judge or judicial officer. If tomorrow another judge goes to court and gets orders to stop accountability, they will come into the list. So the list is going to be dynamic and ongoing until we get a resolution on the question of accountability. And the Law Society of Kenya will consider other possible measures after we receive feedback from our members that is being collated in the course of the day today and in the course of this week against possibly other judicial officers and judges who may be involved with strong evidence in issues of corruption or misconduct. Yes? Yes, so accountability means that every judge or judicial officer, every court registry and the whole institution of the judiciary must answer to Kenyans for the authority they have been given. So there are three mechanisms for accountability. The first is internal. Every judge must fill their performance details, give them to the registrar of the judiciary. There are other methods in which they receive, they have internal accountability. When they sit, they must handle cases, they must give judgments or rulings without delays. They must comply with the internal criteria or guidelines that the judiciary has established. For example, judges are meant to deliver rulings or judgments and upload them on the case tracking system within 24 hours. Some judges and judicial officers don't do it even for 2 weeks or 3 weeks after. Our members are very concerned what happens during that period. Judges are meant to deal with certificates of urgency. Those are cases or applications filed that are very urgent within 24 hours. Some of these certificates of urgency are not dealt with for 7 days, 14 days. Judges are meant to return the court file after they have given a ruling to the court immediately. Some of them keep them in their homes for 7 days, 14 days. So there is a litany of concerns. In the registries, there is continuous request for facilitation or corruption, bribes, because you want your court order that was issued to be processed so that you can get the document. The second kind of accountability is feedback mechanisms. This includes court users committees, bar bench committees. It includes complaints and feedback mechanisms that have been put in place by the judiciary. When our members, the lawyers, give feedback, when clients, the litigants give feedback, many times the feedback is ignored. The third kind of accountability is the external accountability that is run by institutions like Judicial Service Commission, Ethics and Anti-Corruption Commission, and even that one is being frustrated. Okay, so before, because those were the three questions I wanted to take, my immediate predecessor, Faith Odhiambo, is here, 51st President of LSK. I'll allow her to say one thing to the media.
Tumeambiwa maneno ni matatu. Number 1, the boycott goes on. Number 2, we must ensure we bring back sanity into the justice system. And number 3, independence of the judiciary does not mean immunity from scrutiny. And therefore, we ask that even as we boycott today, that there is a reflection by the judiciary, even just looking from how the members of the public have been able to give their feedback. They need to sit down and analyze themselves. If courts have become masters unto themselves, that they can stop they can use court orders to stop the investigations, they can stop EACC from digging out the dirt, they can stop the JSC from being able to handle complaints placed before them, then how can we trust in our courts? The courts have always relied on public trust, and we urge them to win back that trust, because as the elections are coming, we'll be looking unto the courts to have some level of sanity. And we hope that they see this not just as lawyers rebelling, but lawyers calling them out to ask that they must be accountable. Their independence does not mean that they are above the law. Thank you, President.
Ni mawakili hawa wakiongozwa na rais wa chama cha mawakili hapa nchini LSK, Charles Kanjama.